Hello, guys, and welcome to another episode of our civil litigation mock trial course by the Dear Core Daniel School of Law. And on today's episode, we'll be talking about affidavit in support on motion for summary judgment. The draft for that affidavit in support for a motion for summary judgment. In our last drafting class, we talked about how to draft a motion for summary judgment under Order 11 and Order 13 of the Abuja rules and the Lagos rules. When is the Lagos rules under 13? When is the Abuja rules is under 11? We talked about that draft in our last drafting class. Right now, one thing that law school does is that law school can tell you to draft the affidavit in support for that motion for summary judgment. And the reason why law school does that is because law school wants to know if you understand certain elements, right, of summary judgment, some facts that must, as a matter of law, be deposed to in the affidavit. If you can understand that, that's what law school is looking for. Do you understand? While we are interrogating the facts in this class, we will look at those key things to touch. Now, when we are talking about our drafts, in our draft for affidavit, just like our draft for the interlocutory application, the motion ex parte, motion on notice and all that, you must have the heading of the court. So you can see that if you do not understand jurisdiction very well, and you go and draft in a wrong heading, from the beginning you have failed. Do you understand? From the beginning, you have failed. So which means jurisdiction, our class 2 on jurisdiction is very, very, very important. So which means that our module 2 on jurisdiction is very, very important. Please don't joke with those lectures. If you have any question on those lectures, please let me know. I have already taught every single thing that you need to know for the purpose of drafting and for the purpose of law school in terms of jurisdiction. I have drafted it already. Now, after our heading, what's the next thing? And I've taught you how to draft in the High Court of Lagos State, in the Lagos Judicial Division holding at Lagos. If it's in Abuja, in the High Court of the Federal Capital Territory, Abuja, in the Abuja Judicial Division holding at Abuja, right? There is no in the Ekpe Judicial Division or in the Ikorodu Judicial Division or in the Surulere Judicial Division, because when you are talking about law school doesn't care about the specific judicial division. In the Lagos Judicial Division suffices. And then after we talk about the heading of the court, which basically is the jurisdiction of the court as we have learned in our module 2, the next thing that we need to look at is suit number. I told you that if you don't add that in your drafting, that's minus half mark, right? Then after that, we look at the parties. Because this is an affidavit, it's basically the same thing that you write in your motion paper that you write in your affidavit. You just replicate it. So if you missed it in your motion paper, not only have you missed the marks attributed to your motion paper, you are going to miss the same mark in terms of parties, jurisdiction, and every other thing that is similar attributed in your affidavit. Do you understand that? So now look at the parties clause. Now it's the same thing as we could find in our motion for summary judgment, right? And I told you that I already taught parties to a civil action, which is our module 3 for our civil litigation mock trial course. I have taught it already. Every single thing you need to know about parties, right? It is already there. So now in this case again, you must add your claimant applicant or your defendant respondent or your claimant respondent and your defendant applicant as the case is. In this case, it is claimant applicant and defendant respondent. Then the next thing now is that we are looking at affidavit in support of motion on notice for summary judgment. You know that if it is the motion paper now, we are going to either state that this one is motion on notice or this one is motion ex parte. Do you understand that? But in this case, we are saying it is affidavit in support. Don't just write affidavit. You will not get the mark. Affidavit in support of what? Affidavit in support for motion on notice. What motion on notice? Motion on notice for summary judgment. You must write it in full. Affidavit in support of motion on notice for summary judgment. Very important. Now, the first paragraph, the first thing that you have in your affidavit is what I, put as an acronym. Now, this acronym is not a sexy acronym. It's just very, very, I just wanted to cram it and learn law school and pass. So it is NGAOKA, right? NGAOKA. So NGAOCA. Just learn it. It's not sexy. Ngaoka, Ngaoca, right? So you are saying N, name, G, gender, A, adults, because it has to be adults, then O, occupation, then C, which citizen, then A, address. So you know the first thing is I, comma, then you put the name. So I, dear Kolola Daniels, comma, then what's next? G, male or female. So male, comma, then what's the next? A being what? Adult. So you know I put adult. What's the next? O being occupation, lawyer. Then what is the next? C, Nigerian citizen. What is the next? A, right, which is address of numbers so and so and so, do hereby make oath and state as follows. Do you see that? Do hereby make oath and state as follows. So you can see the Ngaoka helps you, but it's just that it's not something that it's something that you have to be intentional about cramming, because the moment you can cram that and remember, right? Ngaoka, the moment you can cram it and remember, you can draft affidavit very well. That's the introductory part. So I, comma, the Nga, Ngaoca, Ngaoka, Ngaoca. Name, gender, adult, occupation, citizen, address. Now, some people used to add R, which is religion, right? You can also add religion if you remember, right? So you can add it if you remember it in exam. Immediately after occupation or before occupation, you can add Christian, Muslim. Some people add R, but you know, in exam, I don't think I added the religion, right? Ngaoka suffices. Even in practice, Ungaoka suffices. If you want to add R into that thing, it's not already sounding sexy. You now want to write, Ngaoka. And don't forget that when you are drafting, the last thing has to be your address. So you will just say of number. So after the citizen, you usually just say of number. So Nigerian citizen of number so and so. So I couldn't add the R at the end, because if I say Nigerian citizen of number so and so, now write comma Christian, do hereby. Do you understand? So because it would have made sense to say Ungaoka, then the car will now be CAR as opposed to CA. So the religion usually comes after the adult before your occupation. It usually comes around that side or after your occupation, whichever it is. Do you understand? But just follow this. If you remember the R in exam, because I've explained it and we've joked about it. If you remember the R in exam, please add it, right? But if you don't remember, Ungaoka is fine. Then after that, you say, do hereby make on oath and state as what? As follows. Number one is that you must tell us who you are. I am the claimant in this case. Number one, you must tell us who you are. I am the claimant in this case. Number two, this has to be the next paragraph to follow. By virtue of my position above, I am familiar with the fact of this case. It is important that you must state it in the affidavit. You can also state, number one, I am the claimant in this case, and by virtue of this fact, I am conversant with the fact of the case. Do you understand? Or by virtue of this position, I am conversant with the fact of the case, which is still in paragraph 1. But you can do it in both paragraphs, right? So there is no hard and fast rule as to how you do it. Do you understand? So I am the claimant applicant in this case, paragraph 1. By virtue of the above, I am conversant with the fact of the case, paragraph 2. Or I am the claimant applicant in this case, and by virtue of this, I am conversant with the fact of this case, paragraph 1. Simple. You can do it either ways. But those two key things, first of all, introduce yourself and tell us that by virtue of the position that you hold, you have the fact of the case. Those are the two things that must be stated in the initial paragraphs of your affidavit. Then after you have then established those two things, you can now begin to take the fact one after the other. From the beginning, you tell it like a story, like story. You are basically telling a story. We are not doing flashback here. This is not Nollywood. We are not doing flashback. You must start from the beginning. It's like you are starting from when the child was born and when he went to school and when he graduated from school, and when he now had to marry, and when he now had children, and when he now had a good job, and you are going in an order. So let us flow with this order. I engage in the business of buying and selling of computers. That is the first thing, because the judge no know who you be. So you gats tell the judge wetin you be. Oh my lord, I dey buy and sell computer. Now the judge don understand, say okay, this one na businessman wey dey buy and sell computer. What's the next thing that you then write? I entered into a contract. Another thing about the rules of drafting affidavit: don mumbo jumbo everything in one paragraph. One paragraph should contain one information. Don't mumbo jumbo it. Put it in different paragraphs if there is an information that you want to give. So for example, of course, he could have said that I engage in buying and selling of computers, and on so day I entered into a contract with so person, and then you can tell all the stories in one paragraph, of course. But no, that is not how to draft affidavit. When you are drafting affidavit, you must go paragraph by paragraph. Why? Because for a person to respond to the affidavit, that is the respondent, the defendant, he is going to pick each paragraph one after the other, and he will either deny a paragraph or accept a paragraph. So you have to make sure that the information that you are keeping in each paragraph is not such that one part is true, another part is not true. So the defendant will not know how to deny one part and accept one part. Do you understand? You have to outline your story paragraph by paragraph, and each paragraph containing one information. So your paragraph 3 tells us I engage in the business of buying and selling of computer. One information. Paragraph 4 tells us I entered into a contract with the defendant respondent to supply him 100 set of HP laptops in a sum of 10 million naira. That's one information. I entered into a contract with the defendant to sell him so number of laptop for this amount. One information. Another thing that you have to learn in drafting is the contract agreement is herewith attached and marked Exhibit A. That is extremely important. When you have stated a thing that you want to rely upon, and there is an evidence about that thing that you have stated in your affidavit, you must say that that thing is herewith attached. Right? It is herewith attached and marked Exhibit what? Do you understand? Now, in this case, now he is telling us that he entered into a contract with the defendant to supply him 100 sets of computers in the sum of 10 million, and the 10 million naira must also be written in alphabet and numbers only. Right? Now, the contract. What is the evidence of your contract? Will the judge just say, "Oh, not true, not true"? You enter contract. Was the judge there? Church was not there. So therefore, you have to attach the evidence of that contract. So he attached the evidence. The contract agreement is herewith attached and marked Exhibit A. So one information. Now let us now go further. The defendant respondent paid the sum of 5 million naira only, with the arrangement to pay the balance on delivery of the computers. The acknowledgement of payment, that's the receipt of payment, is herewith attached and marked Exhibit B. So you are following A, B. Do you understand? Can you see that there is also one information there? He has paid how much? 5 million, and he said that he's going to deliver the remaining when I give him all the computers. This is the proof. The acknowledgement of payment is herewith attached and marked. So there is another information in our paragraph 4, which is different from the information. You know that he could have added the paragraph 4 and paragraph 5 together. You know that that's very possible. Oh, we had an agreement, and this agreement is that I will transfer him so and so. Then out of this agreement, right, he transferred 5 million to me and said when I deliver the remaining computers, he will transfer the order. You can mumbo jumbo them together, but that is bad drafts for law school and also for practice. You put one information per line. One information, this is what happened. Then after this is what happened. And then I will attach my exhibit. After this is what happened. And then I will attach my exhibits. So you say this so thing is herewith attached and marked Exhibit this. Then now we move on. I deliver the computer to the respondent as agreed. Now in this case, now there is no evidence of the delivery of the computer, probably pictorial evidence, or there was a mail saying, "Oh, I have delivered," and the person said, "I have received." If there was that evidence, then you would therefore attach that I have received the computers as evidence, but in this case, of course, there is no evidence. Now, the defendant failed now to pay the balance. Effort to make him pay proved abortive. You can see how we are going one after the other. Do you understand? I believe the defendant has no defense to this action. This is what they are looking for. This, you see this paragraph, that's what law school is looking for, because it is based on this your belief, the deponent belief, that the defendant has no defense. That is why we are asking about summary judgment. We are asking for an order for summary judgment, because there is no defense. And as we can see, right, if there is actually a contract, right, and the defendant has willfully disregarded the terms of the contract, he has willfully failed to honor the contract, of course there is no defense. Right? So as a judge, if I'm reading this affidavit, I'm more inclined to actually give a summary judgment in favor of the claimant. Now, to move one more step, this is the last thing of every affidavit, and you must cram it. The last thing of every affidavit. I make this solemn declaration conscientiously, believing the same to be true, and by virtue of the provisions of the Oath Act. You must. Right? Now, you can say of the oath law, being that this is the High Court of Lagos, right? And what should be applicable should be the oath law. But honestly, people use it interchangeably, especially in bar finals, right? So, oath act to oath law, both of them suffices. Right? So I make this solemn declaration conscientiously, believing same to be true, and by virtue of the provisions of the old law. You must learn it. I make this solemn declaration conscientiously, believing same to be true, and by virtue of the provisions of the old law. You must cram it in that manner. Very important. Do you understand? Then on this side now, there has to be the signature of the deponent. Right? We already know who our deponent is from our Ngaoka. We already know who our deponent is. And then after that, we now have what? Sworn to at the High Court Registry, Lagos, must, as a matter of fact, be in your affidavit. That part, if you don't have it there, you have problem. Sworn to at the High Court Registry, Lagos. Dated this dash day, before me, then you leave one space for the signature of the Commissioner of Oaths. Do you understand? So you see this part, cram it. Deponent is on the right side. Then sworn to at the High Court Registry, Lagos. If it's Abuja, sworn to at the High Court Registry, Abuja. Then after that, you have dated this dash day. Then in the middle, you now have before me. Then you leave space, Commissioner of Oaths. Please and please learn this thing. So for this affidavit, so far, we have learned Ngaoka. We have learned the introductory paragraphs of the affidavit. We have learned the last two things, which is very, very important. I believe that the defendant respondent has no defense to the action, and I make this solemn declaration conscientiously, believing same to be true and by virtue of the Oath Act. We have learned that when we are carrying our paragraphs, it is one information per paragraph. We have learned that if there is anything to be attached, you will attach it herewith and mark it as what? Exhibit A, Exhibit B. Attached herewith. So the contract agreement is attached herewith and marked exhibit so and so. The acknowledgement of payment is attached herewith and marked exhibit so and so. Right? The first and second paragraph, very important. The fact that you are enumerating one point at a time per paragraph, very important. The fact that you are attaching whatever document you are going to attach per that paragraph to evidence that fact that you have deposed to, very important. The last two paragraphs for a summary judgment is very, very important. Your belief that there is no defense to the action, and I make this solemn declaration conscientiously, right, believing same to be true and by virtue of the provisions of the Oath Act, very important. Then sworn to deponents, right, the deponent on the right side, then sworn to at the High Court Registry on the left hand side, then dated on the left hand side, then in the middle before me, Commissioner of Oaths. And this is where I end my class for today on how to draft affidavit for summary judgment under order 11 or order 13. In our next class, we will talk about some other drafts that we need to learn. I will see you in our next class. I hope you had a very beautiful class. Please have a very wonderful day.